Okay, so we have we've had our discussion of John Locke and our discussion of the Ninth Amendment and the 10th Amendment. And when you look at all of that together, they paint a pretty clear picture that there is such a thing, and certainly the Supreme Court says that there is, right? There is such a thing as a constitutionally protected interest, a constitutionally protected right, right? Even some rights that are not listed in the Constitution. So we're going to study those rights. The purpose of this video is to introduce you to another idea, which is sort of an odd quirk of the Supreme Court. The Supreme Court has never been satisfied, right, with just a citation to the Ninth Amendment. As a matter of fact, some justices have referred to the Ninth Amendment as a mere truism, right? You know, their attitude is sort of, okay, so the Ninth Amendment says there are liberty interests, right, that are constitutionally protected, right? Newsflash, right? Everybody knew that already. So sometimes you'll see that the court, well, often you'll see that the court's not terribly impressed if you're claiming on behalf of your client that your client has some unenumerated right to do something, and the only part of the Constitution that you cite is the Ninth Amendment, a federal court will not be impressed. Now, it might be that is all a federal court should need. I mean, it's pretty clear what the Ninth Amendment says, but for some reason, the Supreme Court, and therefore all federal courts, right, because they follow the lead of the Supreme Court, has always insisted, basically this is what they're saying, right? We get that there's a Ninth Amendment, we get that the 10th Amendment talks about, right, power reserved to the people. We get all that. But those amendments only establish that such rights exist, right? So they exist. And the court has always wanted, don't ask me to explain this because I have never figured it out. The court has always wanted more. They've said, give us some other textual home, right? Some other part of the Constitution where we can hang our hats, right? And put these individual rights, right? These interests. You know, we know from the 9th and 10th they exist, but what other part of the Constitution can we turn to, right, and make that part of the Constitution, again, the textual home of unenumerated constitutional rights? Is there anywhere in the Constitution you can point us to, besides just the 9th and 10th Amendments, to help us identify what these rights are? Now that brings us to the Slaughterhouse cases. The Slaughterhouse cases involve a slaughterhouse that has an exclusive monopoly, right, to do business in a certain area, and there are other butchers or would-be slaughterhouse owners, right, slaughterhouse operators who want to do business in the same area. And obviously, if the government has given one party a monopoly, then that's the issue here. We need state action, right? The government has given this business a monopoly. Then obviously that excludes other people, right, whose dream might have been to own a slaughterhouse, right, whose live stream, and who are claiming what? I should be able to make a living, I should be able to open a business, I should be able to do all that good stuff without the government, right, closing me out. I have a right to do business, and the government is stopping me from doing that. Okay, so we're going to do this a lot throughout the term, right? As you recall from Con Law 1, right, this kind of back and forth of every case, right, how do we set this up? All right. You're saying your client has a right to operate a slaughterhouse, right, and that the state, the government, the city is stopping your client from doing that. Okay, and you go into federal court and you're facing a federal judge, right, and the federal judge says, okay, so you say your client has a right to open a business and the government's interfering with that, right? Okay, what's the judge going to say? Where in the Constitution do you see anything about, right, people having an individual right to own a business, run a business, operate a slaughterhouse, anything like that? And you have to concede what you have to concede, right? That nothing like of that nature is in the Constitution. Nothing like that is listed in the Bill of Rights, right? So then you have to make your argument, right? And you say, Your Honor, this is not an enumerated rights case. This is an unenumerated rights case. The judge might ask you, what are you talking about, unenumerated rights? Aren't constitutional rights all listed in the Constitution? And so here throughout, right, I want you to, I hope you use the pause function, right, on these videos to kind of stop and think about that, right? So I asked the question, pretend I'm a federal judge and you're an advocate and you just said to me it's an unenumerated rights case. Then I shoot back at you, what do you mean unenumerated rights? Aren't all the rights that are constitutional rights listed in the Constitution? What do you cite back to me? Think about it. Right. You cite the Ninth Amendment, and you cite the 10th Amendment, right? You say the 9th Amendment says that there are unenumerated rights, that the listing of rights in the Constitution should not be construed, right, to deny others other rights retained by the people. The 10th Amendment says that there's power reserved to the people, and that means would belong neither to the state nor to the federal government. And here comes the question I was talking about. Now the court says, okay, so in the 9th Amendment, 10th Amendment, they say that there's such a thing as an unenumerated right. Where else in the text, right, can I hang my hat? Now, in the Slaughterhouse cases, we're talking about subdivision of a state, right? So the first thing that the lawyers want to do there is find a part of the Constitution that targets states, right? That applies to states. Wouldn't that would be a smart move? So again, if you're targeting a state or a subdivision of a state, you got to go to the part of the Constitution that targets a state or a subdivision of a state. That is the 14th Amendment, right? Because we've been down this road. The 14th Amendment applies to states. So they go to the 14th Amendment. Okay, now that we're there, these lawyers say, now we got to figure out which clause in the 14th Amendment, right, covers right, what we're talking about here, the right to own a business, some kind of unlisted right. Now there are three clauses in the 14th Amendment. There's a due process clause, an equal protection clause, and a privileges and immunities clause. Now very quickly, the due process clause, when you read it, looks like nothing more than a procedural promise. It says that the government cannot take away your life, liberty, or property without due process. The flip side of that coin is that the government can take away your life, liberty, or property if it gives you due process, right? So the lawyers back then are looking at the due process clause and saying that doesn't fit. We're not asking for a jury trial here. You know, we're not asking for procedural rights. We're asking for a substantive right. Keep that word in your head, right? Substantive right of a person to own a business, right? To have their own economic affairs and lives without the government interfering in that. So they more or less rule out the due process clause. They say that one doesn't fit. We'll be coming back to the due process clause, as you know, but at the time, right, that's what they decided. We're going to go a different route. They decide that this has very little to do with equal protection, right? This is not about equality. It's not like the government is picking on somebody because of some characteristic, right? We'll study equal protection later. What caught their eye, the lawyers for the plaintiffs, right, in the Slaughterhouse cases, was the Privileges and Immunities Clause of the 14th Amendment, right, which says that the state may not abridge the privileges, right, and immunities, right, privileges or immunities of citizens of the United States. That makes some sense. When you look at the words, right, privileges means stuff I'm allowed to do, right, license to do something, a privilege. And what does immunity mean, right? Well, there's a word floating around, right, in current events. But immunity means protection from, right? And of course, when you're talking about the Constitution, right, in a constitutional sense, any immunity would mean immunity from the government, right? So the lawyers decide this clause, this looks like a promising clause, right? It's in the 14th Amendment, which targets states, which is good for us, right? And the 14th Amendment has a Privileges and Immunities Clause, which seems like a very broad promise of liberty, of license to do things, right, without the government interfering. So immunity from governmental interference when I exercise one of my privileges of citizenship. And of course, they're going to argue one of those privileges is, right, the right to earn a living, make a living, own a business, run a business. Now, the Slaughterhouse cases are good, they're a good topic for a video like this because this is not something we want to spend a whole lot of time on. I'm gonna go through what the court said here, and you might have to rewind it several times and listen to it several times before it starts to sink in because it's very convoluted. If you didn't think the Slaughterhouse cases were convoluted, you probably didn't read it very carefully. It's convoluted. There was a lot of debate about the Privileges and Immunities Clause, right? That was adopted, right, in the 14th Amendment. It caused a lot of anxiety. Here's what the Supreme Court says. And I hope you caught this, right? But again, it's kind of convoluted. The Supreme Court says, look, the Privileges and Immunities Clause of the 14th Amendment only protects privileges and immunities of citizens of the United States. Now, the Supreme Court says that privileges and immunities, I don't know if you remember this from Common Law 1, right? But privileges and immunities, because there's another P&I clause in the Constitution in Article 4, typically means, or privileges and immunities, I should say, typically come from your citizenship of a state, not from your citizenship of the United States, right? If you look at the P&I clause of Article 4, not the 14th Amendment, but Article 4, that P&I clause is understood as meaning what? That when you have a right or privilege in one state, right, and we're talking fundamental rights, like again, if you recall, the right to work, the right to acquire property, the right to interstate travel, all that stuff, right? You bring that from one state to another state because this is one country. So now think about that. If the P&I clause only protects, right, privileges and immunities that come with national citizenship, and the court is saying there are no privileges and immunities that come with national citizenship, privileges and immunities come from your citizenship in a state, well, that doesn't leave much there now, does it? It is not an overstatement to say that in the Slaughterhouse cases, right, the Supreme Court basically wrote the Privileges and Immunities Clause out of the 14th Amendment. The upshot is that the Privileges and Immunities Clause of the 14th Amendment only protects, right, the privileges and immunities of federal citizenship, which means those privileges and immunities, right, that arise from federal law and the U.S. Constitution. And of course, if that's all the P&I clause means, then you say, well, thanks for nothing, right? Because I don't need a privileges and immunities clause to tell me, right, that I have certain rights under the Constitution, because the Constitution already says I have those rights. So, again, you know, we could talk around in circles, right, about the court's reasoning in the Slaughterhouse. I always want you to come away with the bottom line, right, of what you need to understand out of the case, is that after Slaughterhouse, after the Supreme Court got done slaughtering, right, the Privileges and Immunities Clause of the 14th Amendment, you can't cite that anymore, right, as the legal basis, right, as the textual basis for unenumerated constitutional rights. The P&I clause is basically a dead letter, right? People, and if you see a question, a call to question that involves somebody suing under the Privileges and Immunities Clause of the 14th Amendment, the right answer is probably 12b6 dismissal. I hate to bring in CIPRO on you, but 12b6 dismissal for failure to state a claim, because the Privileges and Immunities Clause does not protect individual unenumerated rights. Where does this leave us? The 9th Amendment and the 10th Amendment together make a strong case that there's such a thing as an unenumerated right. The court agrees. The court says we want something else to hang our hats on, though. Give us another part of the text where we can put these rights that could guide us as to what these rights are. In Slaughterhouse, advocates tried to use the Privileges and Immunities Clause, right, as that hook, as a textual hook on which the Supreme Court could hang its hat. They failed. The Supreme Court obviously was not ready during that era to get into the whole business of trying to define unenumerated rights and cabin those and define the scope of them. They weren't ready to get into that business, so they basically said, the P&I clause doesn't mean anything. Okay, so where that leaves us is where we're headed. If the P&I clause is not the natural home, right, for unenumerated rights, is there any other part of the Constitution that might be? And as you know from your reading, courts eventually came around to saying yes. The word liberty in the Due Process Clause, and remember there are two of those, one that applies to the federal government and one that applies to the states. The word liberty in the Due Process Clauses isn't just a promise of procedural fairness. The word liberty used in the Constitution presumes, right, a sphere of life, right, where citizens are free if we are, again, to style ourselves a free country. So, thus was born the doctrine of substantive due process, right? Substantive due process is basically what the court had to invent after it killed privileges and immunities, which was probably the more natural home for unenumerated rights, right? When you look at those three clauses. But the court killed P&I. They've never overruled themselves on that. Instead of admitting that they made a mistake, in the Slaughterhouse cases, they just invented, right, another term, substantive due process, right? And they hang their hat on the word liberty in either the 5th Amendment if you're going after the federal government, or the 14th Amendment if you're going after a state or a subdivision of a state. So that's enough for this video, but I wanted to set up our live session discussion with a little bit of information, right, background, including the Slaughterhouse cases, right, and how we got here talking about the Due Process Clause as the home of unenumerated fundamental liberty interests. Stay safe and stay tuned.